India Legal presents Courts Roundup.
Hello, I'm Hishe and you're watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceeding. Before we begin, here's the headlines. Lucknow bench of Allahabad High Court takes suo motu cognizance of Hathras case, asks Registrar to file PIL, summons top officials to court. Ban for congenital heart condition. Mohammedan Sporting Club footballer Anwar Ali files PIL in Delhi High Court, says, "Let me play." Allahabad High Court issues order to regulate eateries during COVID, issues a set of instruction for eateries and restaurants.
India Legal presents Courts Roundup.
The Lucknow bench of Allahabad High Court has taken suo motu cognizance of horrific Hathras gang rape case and the issue of the UP police of handling the body of the victim to the family and cremating it forcefully at 2 a.m. instead. The bench has directed the senior registrar of the court at Lucknow to register a suo motu public interest litigation and place it before the appropriate bench having jurisdiction to hear PIL. The bench has also directed the family members of the deceased victim to be present before the court so that court ascertains the facts and their versions of the incident which took place at the time of cremation.
The Allahabad High Court has taken suo motu cognizance over the pre-dawn cremation of the 19-year-old Dalit woman who is stated to have been gang raped and mutilated before succumbing to her injuries in Uttar Pradesh, Hathras. The order passed by a bench of Justices Rajan Roy and Jaspreet Singh states the court has taken serious note of reports indicating that the body of the victim was forcefully cremated without the consent of her family. The High Court order states, "We are inclined to examine as to whether there has been gross violation of the fundamental rights of the deceased victim and the family members of the victim, whether the state authorities have acted oppressively, high-handedly and illegally to violate such rights, as if it is found to be so, then this would be a case where accountability will not only have to be fixed, but for future guidance also stern action would be required." Media reports informed that the family was prevented from seeing the victim even as they begged the police not to cremate. The High Court notes that while the police authorities later insisted that the cremation had been done with the family's consent, media interviews with the family of the victim suggested otherwise. Disturbed by the reported sequence of events, the High Court points out that it is settled that even the dead have a right to be treated with fairness and dignity as laid down in cases. Given this position, the High Court has emphasized that if allegations of forced cremation are found to be true, it would be a case of gross violation of basic human and fundamental rights enshrined under Article 21 and Article 25 of the Constitution of India in a most blatant and uncalled for manner, something which is absolutely unacceptable in our country governed by rule of law and the Constitution. We would like to examine as to whether the economic and social status of the deceased family has been taken advantage of by the state authorities to oppress and deprive them of their constitutional rights. The court adds, the bench has also said that it will leave the question of whether there is a necessity to monitor the investigation or to get the investigation done by an independent agency as per law. The court has directed the senior registrar of the court's bench at Lucknow to register a suo motu public interest litigation with the title in reference right to decent and dignified last rites, cremation, and place it before the appropriate bench having jurisdiction to hear the PIL. The matter has been listed to be taken up on October 12th. The family members of the victim have also been directed to be present before the court so that the court can further ascertain the facts. The following state functionaries have been summoned to put forth their version of the case with supporting material to appraise the court regarding the status of the investigation on the next hearing date. These officials are the Additional Chief Secretary, Principal Secretary Home, Director General of Police, Additional Director General, Hathras, District Magistrate, and Hathras Superintendent of Police. In the meanwhile, the court has specifically set out the state authorities are directed to ensure that no coercion, influence, or pressure is exerted upon the family members of the deceased in any manner by anyone. Senior Advocate Jaideep Narayan Mathur and Advocate Abhinav Bhattacharya have been appointed as amicus curiae to assist the court in the matter. Bureau Report.
The bench comprising Justice N.V. Ramana Suryakant and Rishikesh Roy set aside the conviction of a husband who was accused of driving wife to suicide. Gurcharan Singh was convicted for abetting suicide of his wife. Singh, along with his parents, were charged under Section 304B and 498A, read the Section 34 of the IPC. Though the trial court noted that there was insufficient material to convict them under Section 304B and 498A IPC, it opined that even if no charges of abetment was framed against the husband, he can be convicted for abetting suicide of his wife under Section 306 IPC. The trial court also observed that expectations of the married woman will be love and affection and financial security at the hands of her husband, and if her hopes are frustrated by the act or by willful negligence of the husband, it would constitute abetment within the meaning of Section 107 IPC, warranting conviction under Section 306 IPC. The High Court endorsed the trial court's view, referring to Section 104 of the Indian Penal Code. The bench noted that whenever a person instigates or intentionally aids by or any act or illegal omission the doing of things, a person can be said to have abetted in doing that thing. The Supreme Court yesterday granted a bail to a man accused of aiding the escape of a terror suspect when the bench found that the man had not been named in the FIR. While not interfering in the progress of the main investigation, the top court set aside this order of the Rajasthan High Court. The accused had been charged under the Unlawful Activities Prevention Act 1967. The top court observed the High Court, stating that a prima facie case has been made out against the petitioner based on the public prosecutor's statement cannot be said to be strictly correct. The accused had been charged under Section 43D5 of the UAPA for aiding the escape of a terror suspect from whose house explosive materials have been recovered by the police. On pursuit of the FIR, the bench comprising Justice R.F. Nariman, Naveen Sinha and K.M. Joseph said that the accused had not been named in the FIR. The bench further said, having pursued the documents without saying anything more so as not to prejudice the trial, we set aside the judgment of the High Court. The bench directed that the accused be released on bail subject to the usual conditions to be imposed by the trial court. even as a congenital heart condition threatens to end the budding career of FIFA Under-17 World Cup team defender and current Mohammedan Sporting Club footballer Anwar Ali. The 20-year-old has reached the doors of the Delhi High Court for respite. He is fighting against a ban order by the All India Football Federation. The court yesterday adjourned his hearing against the ban to October 20th. The player had been banned by the AIFF because it is a life-threatening condition and a high-tension sport such as football could end his life on the field. Such instances, though rare, have happened before. The petition filed by Ali states that he has challenged the letter and the proceeding pending before respondent number 2, the AIFF, as the same is being done in a bid to take away the right to earn a livelihood of the petitioner in a completely opaque, whimsical and arbitrary manner without following any rules, regulation or due procedure. The counsel appearing for Ali pleaded before the bench that Ali should be allowed to continue with the game till the consideration of the medical committee. Ali has been diagnosed with hypercardiomyopathy, after which the AIFF wrote a letter on September 7 to the Mohammedan Sporting Club, directing the club not to allow Ali to train with the team on account of his heart condition. Mohammedan Sporting starts playing in the Indian Super League on October 8th and Ali would have been their mainstay in the defence. Twitter celebrity Samir Thakur had filed a plea before the Bombay High Court seeking direction to quash and set aside an FIR filed against him for allegedly tweeting abusive content on his personal Twitter handle against the present Chief Minister of Maharashtra, Uddhav Thackeray. During the hearing, the bench orally accepted the statement of AAP that the concerned police station in Mumbai would not take coercive step against Samir as long as he continued to cooperate with the investigation. Samir has been charged with bailable offences under Section 292, obscenity, and 500, defamation of the Indian Penal Code, along with Section 67, obscenity in electronic form of the Information Technology Act. Advocate Chandrachud submitted to the court that it was the fundamental right of a citizen to criticize a public office. He referred to several judgments of the apex court which observed that those who occupy a position in power have to develop a thick skin. The FIR against Samir in Mumbai was allegedly filed upon the instance of an employee in the Shiv Sena legal head cell. After a few days of registering the FIR, the police station sent him notices under Section 41, arrest without warrant to appear to the station. Samir, who is a resident of Nagpur, requested the Mumbai police station to exempt his attendance in view of the ongoing COVID-19 lockdown. He filed the present petition before the principal bench of the High Court when the Mumbai police refused to exempt his attendance. A division bench of the Calcutta High Court has refused to offer interim relief to Harshvardhan Lodha on an earlier probate court judgment that ordered his removal from all MP Birla Group companies. Last month, Harshvardhan Lodha and MP Birla Group entities filed multiple applications before a division bench of the Calcutta High Court, challenging a single bench order restraining Lodha from holding any post in the group. The court has asked for affidavits to be filed by October 21st and replies by November 17. The 16-year-long legal dispute between the Birlas and the Lodha family took a fresh turn last month after a single bench of the High Court stopped Lodha from holding any position in the conglomerate. In September this year, a probate court had ruled that Lodha should be removed as chairman of Birla Corporation and also as a director on the board of other MP Birla companies, including listed firms Vindhya Telelinks Limited, Birla Cables Limited and Universal Cable Limited. The order was a significant victory for the extended Birla family, which is contesting the legal validity of the Priyamvada Birla will. HC Lodha, who succeeded Priyamvada Birla as chairman of the MP Birla Group, died in 2008. And can deputy commissioners of police can be appointed as executive magistrate under the CRPC, which contains provision allowing executive magistrate to exercise certain judicial power, where there is a statutory bar on the policeman from exercising judicial power under the District Police Act 1859. Justice P. N. Prakash of the Madras High Court had deliberated on this question, recounting in some details the history of the law and its intent, before opining that deputy commissioners of police cannot be permitted to act as executive magistrate under the Code of Criminal Procedure. However, given a contrary ruling by another coordinate bench of the Madras High Court in Balamurugan versus State, Justice Prakash has now placed the matter for an authoritative pronouncement by a larger bench. Section 122(1)(b) CRPC allows executive magistrate to order the imprisonment of person who breach the condition of a bond executed for keeping the peace and without sureties. In question in government order passed by Tamil Nadu government in 2013 and 2014, whereby Deputy Commissioner of Police in Tamil Nadu were vested in the power to act as executive magistrate under the CRPC in various districts of the state. The court has opined that while the Commissioner of Police is an executive magistrate ex officio under Section 7 of the City Police Act, he cannot delegate his power to the Deputy Commissioner of Police. The state government has informed the Karnataka High Court that it has proposed to consider transgenders as one of the categories in other backward classes, in consultation with the Karnataka State Commission for Backward Classes Commission for the purpose of recruitment. This was told to a bench comprising of Chief Justice Abhay Srinivas Oka and Justice Ashok S. Kinagi, while dealing with a plea challenging a state government notification pertaining to police constable recruitment on grounds that it did not include a separate category for transgender person on par with men and women. The affidavit filed by the Chief Secretary of Home Department further informed that the state government could take a decision in the above matter after consulting with the Commission. The affidavit further affirmed that the said Commission will have to reconstitute. Further, the court said that this issue will have to be considered in the light of Article 342A of the Constitution of India. The court observed what is the effect of 342A of the Constitution. The legal position will have to be examined. The case of a Maratha reservation before the Supreme Court also found a mention during the course of hearing. If we recollect properly, the observation of the Supreme Court in Maratha reservation matter is the role of State Commission for Backward Classes vis-a-vis the reservation for the other backward classes. That seems to be the argument before the Supreme Court. The bench further clarified that the role of Commission was questioned to be considered. The state government further mentioned that it had to ensure that reservation does not cross 50%. The matter will be heard next on October 16th. The Karnataka High Court has further extended the life of interim order passed by its subordinate courts and tribunals, which were due to expire within 1 month till November 29. When the matter was listed again recently, a division bench led by Chief Justice Abhay Srinivas Oka extended an order dated April 16, 2020 till November 29, 2020. By the April order, the court had first extended the life of interim order in view of COVID-19 pandemic. The following interim orders have been extended now to ensure that litigants do not suffer on account of their inability to approach the courts of law. All interim orders passed by the Karnataka High Court, all the district courts, civil courts, family courts, labour courts and industrial tribunals and all other tribunals in the state over which the High Court has the power of superintendence, which are due to expire within a month. These orders will continue to operate till November 29th. It was clarified that those interim orders which are not of a limited duration and are to operate till further orders will remain unaffected. All bail anticipatory bail orders which are likely to expire in 1 month will stand extended until November 29. All eviction, disposition or demolition orders that have already been passed by the High Court, District Court and Civil Court shall remain in abeyance until November 29. This apart, the court has also urged the state government, its agencies and instrumentalities to slow down the procession with respect to taking action on demolition of structures and eviction of persons. Well, that's all for the Courts Roundup today. Thank you for tuning in. Keep watching APN for more updates from around the nation.
India Legal presents Courts Roundup.